I've had a couple of those. So that's what's going on. So even when you're approved and think you're going to collect unemployment benefits, you end up not collecting. And I represent employers too, and I tell them this, it's like, don't even worry about unemployment anymore, because the odds are of someone actually collecting are so difficult that they're not going to accomplish it.
Well, so are they, using statisticians and behavioral theorists to make it impenetrable? Or?
It's gumming up the work. So in 2007, when you filed for unemployment benefits, you had to answer, I think, 9 or 11 questions on the phone. Now you have to answer about 130 to 150 questions.
So, and who created that? Who made that happen?
That was created back in 2014 is when the process started, and picked up in 2016, 2017, and nothing, and it's not being changed now. That's the difficulty. All this stuff is in place, and getting it addressed and fixed is impossible, because the argument is now we have to do it this way. And then when I push back and say, well, why? Well, because these legal requirements. And I say, well, what legal requirements? And then I will get some specific and I'll look it up, and it's like, no, that's not true.
So I'm just going to push back on impossible, because it's clearly an intention, right? This is artificial. This is a human interaction that's causing this, and could stop it too, right?
Yeah, I mean, and a lot of the questions right now aren't even legal. They actually violate current Wisconsin law. I mean, so like I posted on my unemployment website, like the available questions. You're asked, are you able to work 32 or more hours in a week? And the other question is something along the lines of, are you available for work from any employer for up to 32 hours or more in a week? And I mean, that second question is so confusing. Most people say, well, I was let go, so I'm not available for any work because I'm not being offered any work. And so the answer no. And so technically they're supposed to answer yes to that question. The problem though with both questions is, if I have a there's a regulation that says if I have a physical or mental impairment that limits me to only, let's say, 15 hours a week, but as long as I'm willing to work up to 15 hours a week, I am considered able and available for unemployment purposes for up to 40, whatever amount. I'm considered able and available, even though I can only work 15 hours that week. So the law actually says, if you're willing to work however many hours you're capable of working, you're able and available. But that's not the question being asked of you. The question being asked of you is like, are you able to work 32 or more hours in a week?
But it's sort of like the LSAT, where you're trying to get the least wrong answer and not necessarily the correct one, and you're getting penalized for sort of being accurate.
Yeah, and so you can't, if I can work 15 hours a week, I should answer that 32-hour question yes, because the question is wrong. It's not the law. The law is, in Wisconsin, you should just be asking people, are you able to work as many hours as you're capable of working?
Right.
That's it. Are you available for work? Should work be offered to you? That should be the question.
So Victor, I know you've got a big win on the circuit court, and I'd like you to explain that to us. Also because of how it fits into this procedure here. But if I was coming to you with an unemployment question, what's the one thing you'd want me to have done before I come to you?
So I have an unemployment website, so wisconsinui.wordpress.com. And basically what I do when anybody contacts me now is I say, I basically get their email address and see if they can do stuff by email. And then I send them a 6-page long email message, which is basically an index to my unemployment website. And the first couple of links in that email are to the unemployment primer, which is basically a description of the basics of unemployment, and some tips about some, just, just major disqualifications and major issues that may come up. And then the other thing is how to navigate the portal, because the portal is how you're supposed to interact with unemployment, and it's a mess. And it's usually not accurate and not very, I should say, enlightening. I'll use that word. So there are, like, one is a secret. You have to do the secret thing to get your document history, and you won't see administrative law judge decisions, or you won't see Labor Industry Review Commission decisions, but you will see your initial determinations and your hearing packets and your hearing notices. So I tell people, go look at that. And the other thing is to look at your benefit payment history, because unemployment is a weekly process. It's not, every week is different, and you're supposed to be structured about every week you're claiming. And so you need to be able to see what's actually happening with your weekly certifications for every single week. And how are they being handled? When are they being handled? And so you need to look at that kind of weekly payment history, benefit payment history, to kind of see what's going on with all your weekly certifications. And unfortunately, there's no way to get at that except to kind of look up this information. And you can only do it on your desktop. If you try it on your smartphone, you won't get a good readout. And then you have to take screenshots of what's displayed on your computer screen.
Wow. Okay.
So
an IT degree helps.
Yeah. So I'm doing a lot of, like, helping people to get that information, and it takes, guiding them on how to do screenshots of their computer screen.
Okay.
So,
Yeah.
and I meet with Department of Labor officials, and one of the things I'm really trying to impress on them is they're trying to create some standards, or at least models, for claim filing ease, and trying to portray as, if unemployment really is this weekly thing, you need to present that weekly information to people right from the start. They shouldn't have to figure out that this is weekly and kind of track all that information in their head going from week to week. You need to present it. Here it is, these weeks. And almost like a calendar, so that they can see, I'm claiming for this week right now, as opposed to, this other week, because that's what, we talked about the administrative concealment penalties. People make mistakes because they think, I'm doing it for this week or that week. They get a 2-week paycheck, and they don't know which the wages belong in which week, or they think they're reporting their hours and pay for this week when it was this other week. And because if you make a mistake, it's presumed to be fraudulent. There are no honest mistakes, according to the department. You have to then, pay back a lot of money when you get charged with fraud. And so, if you actually made this simpler to understand so people could track this information, then they would avoid those mistakes. But right now, the problem with the portal is, I would say it's intentionally meant to confuse you and to keep you from understanding what's actually going on, so that you have to put all this information together.
So that's, it's that intentionality. It's one of the big things that we try to focus here on that channel, or this channel. And so one of the questions I'm asking is, to what extent is this a political decision? And we're talking about making the process more difficult. And what extent is it a bureaucratic decision / bureaucratic inertia?
Well, I think it's both. It was a political decision to gum up the works, and then what's happened, keep in mind the context here. The Department of Workforce Development, like a lot of state agencies, went through a wave of retirements after Act 10. And so you had a lot of personnel who had a lot of institutional knowledge left. Then you had a lot of people, the remaining people, who lacked the institutional knowledge. And you had, frankly, a lot of promotions through political hiring. even through the classified civil service, which has largely been eliminated in state government. I mean, it's still it's now a very political process. It may be a little bit better now, but under Governor Walker, it became very highly politicized. And so those people are the middle managers now running the show. And how you get promoted, how you stay on a job. And remember, all state employees now have a 1-year probation period, which is just a ridiculously long amount of time. I mean, I work with employers. If you, as an employer, when you hire someone, if you don't know that person is going to work out after 3 months, then there's something wrong with your operation or your hiring process.
Right.
Well,
it's just to get around that property interest.
Well, the 1 year means you can do whatever you want with folks, and as a result, they are highly incentivized to do what is politically expedient.
Right.
And so it's created a huge pressure now to be political in all your decisions.
Now, when you say all employees, you're talking about like even an ALJs have the 1-year probationary period?
Yes. Well, those that are actually hired, but what happened with unemployment was a wave of about 20 to 40 were hired as long-term employees for these 6-month appointments.
Limited term.
Yeah, limited term, long-term, limited term employees. And they've got about 2 weeks of training, which was, from all appearances, was just abysmal.
And evidence.
Yeah. So if you did any employment hearings, you saw kind of just mind-boggling that you learn in first year law school is not due process.
Well, a lot of what we do here is show ERD hearings, and I think that's pretty evident there too.
Yeah, I'd say the administrative law judges and ERD, there may be complaints about them, but they're miles ahead of what I'm seeing in unemployment. I mean, I appreciate everything is relative. I've had like judges question witness about well, I'm looking up this new information on my computer screen, and it says X. Do you agree with X? We're not even explaining what why this information is on this computer screen, how the judge got access to it, and what else is on the computer screen. It just
how do you do that?
You object, say, Judge, if you want to ask, you should print the document up and continue the hearing, so that let them look at the document. But the judge, no. Objection overruled. Answer the question anyway. Because you can never object to a judge's question and win. I mean, I've actually had judges have asked so what did your lawyer tell you about this issue? And I'm like, objection, that's confidential and privileged information. I overruled. I want you to answer it anyway. I mean,
I've directed my client not to respond.
Right, but I mean, that's the kind of, usually that objection, the judge will kind of backtrack, say, oh yeah, I remember that now, attorney-client privilege. But in a couple situations now, they've ignored it and demanded the witness to still answer the question. And the clients, will say, I'm, refuse to answer. I say, you can't answer that because that's. But that's what's happening in some of these hearings.
I usually just get yelled at.
Yeah, but and this is at least in the ERD, and maybe it's because the ALJs it's a more formal hearing, so they're not trying to, they're just supposed to be ruling on what the attorneys do, whereas in these unemployment hearings, the judges take it upon their shoulders to run the show, and will ask all the questions, and and prevent you from asking, you're not allowed to ask questions the judge deems, doesn't want to hear about. So I've had whole like issues I want to examine that are cut off. And the difficulty of this is, in that kind of situation, you need an appellate body to actually then push back and rein in these practices. And unfortunately, I think for various reasons, and one of it is just the massive amount of cases that have appeared I think in the first year of the pandemic, the Labor Review Commission was really trying to set straight some of these issues. And we saw a lot of reversals. But I think as the crushing caseload emerged, and remember, the Labor Review Commission never got any additional support staff. So essentially, what
3 commissioners, 7 assistant attorneys, and like a secretary and some LPE.
Yeah, that's it.
Yeah.
And their caseload went from a couple thousand employment hearings a year to 7,000 or 10,000. So essentially what the department said is, it doesn't matter if we screw up all these hearings, we'll leave it to the Labor Review Commission to fix that problem. And the Labor Review Commission just administratively can't do that. And I think maybe, I don't know what happened, but they stopped, calling out some of these bad practices.
Okay. And let's say the problem I have with that is if you don't have a valve for due process and you've got hearing examiners who don't know their job, then as an attorney, you're basically left with will to power.
And well, it's even worse in the unemployment because 95 to 98% of all the cases are unrepresented. So non-lawyers don't know about what's happening and how they're being abused in these hearings. I mean, one of the things that just infuriated me is, from the training of these new administrative law judges, was they would immediately say, and do I have your permission to take it? They would say this at the start of the hearing. Do I have permission to take administrative notice of any documents that I feel I need to take administrative notice of? That's just a clear abuse of power. There's no due process anymore in that situation because the judge can now really later on writing the decision outside the hearing, just look up anything.
Right.
And then incorporate that in the decision if you as a claimant said yes to that.
And of course you're going to, or likely going to, because you're a first time.
And most claimants would never even understand that this is a violation of the due process.
Right.
And the administrative law judges should know that's a violation of due process and they shouldn't be doing it.
Mm-hmm.
But they were doing it with a ban. I think there was one ALJ who was a former defense counsel who was not doing it.
There's the ALJ at the ERT who was a circuit court judge, and he has a reasonable education in how to conduct a hearing.
Yeah.
Let's not forget that an ALJ is really a hearing examiner.
Well,
and their job is to examine, not fact find.
Well, they have to make findings of fact. I don't see the difference between a hearing examiner and administrative law judge. They're the same to me.
Sure, and when I said fact finding, I'm just talking about going out and finding facts. I see the fact discover.
Yeah, they're not supposed to be doing their own intrepid examination and finding information on their own. That would be ex parte, ex parte communications.
Sure, especially with the internet.
But that's what goes on in the employment hearings, especially because they have access to all the entire case file and all these things. So and I've had this happen too, where, I'm at the hearing about like pandemic unemployment eligibility, and the business closed, the person got let go, And then all of a sudden the judge said, well, I have this employer statement that says, they fired you for like driving the forklift without a license. And it's like, what? It's like not in the file at all or anything. And it just starts asking all these questions about this issue. Because the person just gone and searched for information. And you don't even know the information is correct or not because you can't see it.
It's what competent evidence tested on the cross-examination is supposed to be, right?
And so and especially and so at least a representative person I can say, Judge, you object to this, where is this coming from? Can you explain? And the whole part of this, judges can't be witnesses, but here they are now testifying about all these documents they are now finding on their own. But again, if you're unrepresented, you don't know this, and almost everyone, the tendency, especially here in Wisconsin, is you want to be nice. And so the judge starts probing this thing, so you go along with it. You don't want to antagonize or reject or accuse the judge of not following the law. So you will answer the questions, and wherever that goes, even though there's no factual, evidentiary, legal basis for any of it. And so that's, I hear lawyers who do unemployment hearings on occasion, and they contact me and they're going, oh this is terrible. I don't understand. How can this is not legal process at all. And what I hate to say is, and I'm hearing from the folks who had no attorneys at their hearings because they're contacting me about appeals or they're contacting me about collections, and I'm hearing their stories, and I tell them there are hundreds, thousands of people like you, because I'm hearing from all of these folks about this terrible situation has happened to them, and they're not alone. The problem is they don't know that this has happened again and again and again and again and again to thousands of people.
But the DWD knows.
Yes, the department knows, and again, the incentive right now is that's how it wants to operate. It's been set up that way, and there's not enough political will to address these problems and really fix it.
Well, let me just add.
I can tell you a little story here. When Evers won the election, people were contacting me about the secretary's office, about DWD, about possible people who might run that division. And I contacted some people about see if they might be interested because I thought they might be a good fit. Almost everyone I talked to said no. And one person said, I remember this statement, unless that person had the authority to really clean house, they wouldn't go near it because it was a pit of vipers. And that rang with me because I've seen, what happened with a bunch of staff there who didn't retire, and they got hounded and chased out if they didn't toe the line. And so what's happened there now in that agency is it's politically very unified around this idea that unemployment should not be had by anyone.
I think people are right.
And so it's the lower level staff gets hired and tries, and they want to help people. Mm-hmm. And these are the people, I used to have sources in middle management and higher as well as lower levels, but now I just have sources in the lower levels. And what happens is, they see the writing on the wall, that there's no future in that agency if you actually want to be nice to people.
All right, many techo farsi. All right.
Yeah.
Well, because I want to make this parallel here between me sort of feeling like I'm crying out in the wilderness and equal rights, and your position, but I think very much doing the same thing at unemployment. And how if people don't work together, then all they can do is cry out in the wilderness and wish that they had. And I think that, let's say, at the unemployment level, at all levels, at the DWP, that if we don't work together, we're just going to look around and say, we wish things could be better.
Yeah. And part of it is getting organized. So one of the things coming from Massachusetts was the lawyers there on the employer side talk with each other across, areas of focus, and on the employee claimant side, likewise. So like Greater Boston Legal Services, they represented a lot of people in unemployment proceedings. Their attorneys were in contact with the union attorneys.
Right.
And I said the union attorneys and the employment discrimination attorneys would represent people at unemployment hearings. So there was always, a feedback loop going on about all these different issues, so that people understood and knew what was going on. And there were lots of, the unions necessarily didn't get along with each other. Like I was just, the Teamsters were split between a Hoffa faction and a Reform faction for a while, and Boston was a major hotbed of that kind of conflict. SEIU has numerous internal conflicts going on back and forth, and the police unions fractured. And while I was there was a raid going on between an upstart police union was raiding another union for their membership, and so we had lots of representation petitions going back and forth through that raiding. But the attorneys would still talk to each other and communicate on these broad scale issues. That's not happening here in Wisconsin. I'm not seeing, kind of like, get together on these different discussions. I was involved with the Jobs with Justice chapter in Boston about trying to reform some of the internal unions. Here I don't see any kind of effort to kind of like, there's some not so good unions in Wisconsin. How do we, address some of those, problems? Not, if you kind of question a union, then you're seen as a big problem. Mm-hmm. And you may be on the outs. And we don't talk about these problems with the unions. We don't talk about the membership because the unions don't want to appear to acknowledge their deficiencies in any way.
I can tell you as an employment lawyer, it's a natural reaction not to try to criticize the union.
Yeah, and so it's that I think in part led to why Act 10 and the whole divide and conquer strategy worked so well, because they, the progressive forces in the state were very flat and not well organized. And so we were reactionary when all that happened, as opposed to kind of figuring out that this was going to happen. And
one of the things I like about unemployment is it really touches everybody. I don't think it's so much of a left-right issue as, discrimination, because most, if not everybody, is going to have some kind of unemployment in their life.
Yeah, and you talk about my big court case. So and that's the almost universal. It's a universal issue. Is this SSDI eligibility ban that Wisconsin has, back in 2013 and then in 2015 instituted this. If you get SSDI benefits, you can't get unemployment benefits. And this was under this presumption that disabled people don't work. Well, it turns out that's completely ludicrous. Lots of disabled people work, and while they still get SSDI benefits. And so you've created a situation now that a huge part of the workforce is now denied unemployment benefits. And it's reasons why the trust fund never seems to go down that far, because you've excluded a whole population from getting unemployment benefits to begin with when they get laid off. And employers know this now, and they're actually laying off their disabled people first because they know they can't get unemployment benefits, which is discriminatory, which opens up this whole avenue for discrimination claims, which are probably going to start happening, once people start understanding this. But when this happened, when the pandemic, when the layoffs were so universal, everyone contacted me about this, about they can't get disabled people get unemployment benefits, and politically, everyone hated it. You could be an arch conservative National Rifle Association member, you still hated it because your disabled kid wasn't getting unemployment benefits. You were a member of the Communist Party, you hated it because your disabled spouse wasn't getting unemployment benefits. It just was universal. The only ones who accepted this and were the politicians who originally passed it.
Mm-hmm.
That's it. And DWD. No one thinks it's a good idea. No one understands it. And so we finally had a court case where the DWD moved to dismiss it outright, saying, because the legislature enacted it, it can't be challenged.
Mm-hmm.
And the judge was like, no, this can be challenged, and because it doesn't have to, just because it's part of the unemployment law doesn't mean it's right.
And this is a circuit court judge.
Yeah.
Okay. Well, that's pretty great.
So I haven't won yet, but it just means, I've stated a legal claim now. And so now, and essentially we get to brief the whole issue all over again.
But does it also throw a kink into their plan of running to Waukesha?
The Waukesha thing is a different issue. So that's the concealment penalties. So, and this is the thing, I have numerous cases now. I've got about 4 or 5 different issues that I'm litigating right now that are completely unfair and unique to Wisconsin, that no other state is doing this kind of stuff.
That's what I'm really glad to have you here. Thanks so much.
So, but it's taken out, and most of these date from the pandemic. The SSDI eligibility ban dates from before that, but I think, most of them date from the pandemic, and now it's 2023, and they're just now arriving in court. These are things that, and they're mostly involved now is reinterpretations or redos the department has done, and are clawing money back from people.
Justice denied,
So,
or delayed.
yeah.
Wow. Well, Victor, I promised my daughter that I would buy her some spray paint cans and let her spray paint a building that's going to get demolished.
That's a good activity.
Right? Yeah, 12-year-old is the right thing for that.
Yeah.
So it's a pleasure to meet you. I hope we do another one of these, because, boy, I don't think we talked about 10% of what we could have and probably will.
I'd like to, hear some more about the ERD stuff, because I've been so caught up in unemployment now. Sometimes I've lost track of what's going on in other fields.
Well, right, me too. So hey, every step starts with our journey starts with a step.
All right.
Take care, man.
Yeah, thank you for having me.